Thank you, Mr. Chairman. Now, the previous National Speaker spoke about unions versus union members, which struck me as rather odd because union members are the unions. They make up the union. There are, of course, officials elected in unions. Perhaps the member was going to talk about union officials versus the members. But if any union official, and union officials are always elected by secret ballot, if any union official starts to kick the union members around and force them to go on strike, and beat down anyone that votes against the strike or anything like that, those union officials don't last very long, particularly in the next secret ballot election. And when you look at the actual process in the workplace of deciding on a strike, the secret ballot is actually a protection primarily not against union members being pushed around by union officials, but union members being pushed around by the employers. Anyone who's been in a workplace knows that there is the fear of supporting a strike among workers is a fear towards what their employer might think about their decision to go on strike or to vote to go on strike, not a fear of what union officials might think about whether they're voting for or against, because there's usually a democratic atmosphere in the union that the workers insist on, and they accept people voting for and against. But the employer gets rather upset and makes that quite known to the workers if they vote to go on strike. And when the workers go back from the union meeting to the shop floor or whatever it might be, often the person who's in charge, the supervisor or something, will sort of ask them about the meeting and how did you vote and all the rest of it. So the secret ballot is actually a protection of the workers against harassment by the supervisors and the employers, not by harassment by union officials. That is a practicality of the workplace. Now, the question of and I support the amendments being put forward subsequently by Darian Fenton, although I am a little questioning of one of the provisions that it should require a secret ballot in every case of a strike, because as I indicated in my first speech, sometimes that isn't practical. It should be a rare exception, and in any big workplace, normal workplace, public service workplace or whatever, a secret ballot is certainly practical and should be pretty universal. I'm not sure whether it should be in law. But the other, the universality should be in law. The other question relating to rules, and this is where it comes back to this clause in the Employment Relations Act, that this is an act that is supposed to govern the relations between workers and unions and employers organised in some form as employers. It's not supposed to be an act to determine exactly how all the employers conduct their business or how all the unions conduct their business. That is not the nature of the Employment Relations Act. It's an act for relations between two self-determining parties. And this bill is trying to say, well, one of these parties is no longer self-determining. We're going to prescribe exactly how it's going to function. And once you do that, you disrupt that balance between the unions on one side and the employers on the other, because you give the employers the right through pressure on the state or judicial process to then say, this other party, the unions, is not abiding by this or that provision in terms of the conduct of the secret ballot, and I have proof that so-and-so at 36 Lewis Street, Wadestown, or wherever it is, did not get a ballot paper in the mail and wasn't able to participate in the election, therefore that ballot on a strike is illegal, and da-da-da-da-da, and it just causes huge frustration amongst the workers concerned, who otherwise have voted perhaps 95% for industrial action, some strike action, but are hampered by the state getting involved in their internal affairs. That is where it becomes